Hello, everyone, and welcome back. During the session, we would request the participants as much as possible to keep your videos also on so that there's a great interaction that we would have. And the instructor would be able to connect with your discussions better. So it would be fantastic if you could keep your audio. Audio can be turned off for a while, but if you can come on screen, that would be excellent. So, Sheetal, I'll just give a very brief introduction about you because we have a few new participants also here in the session.
Sure, go
So,
ahead.
yeah. So we have Advocate Sheetal, who will be taking us through a very important part of the session, which is on IP transfers, a primer on the IP transfers. I'll very quickly introduce you to Ms. Sheetal. So Sheetal is a practicing advocate. She specializes in litigations and she has over 6 years of experience representing both domestic and foreign clients in various litigations before various fora and arbitrations as well. She started her practice in Chennai and is now practicing before the courts of Bangalore and Hyderabad. She regularly appears in Bangalore and Hyderabad before civil courts, criminal courts, tribunals, and other authorities. And while she focuses primarily on corporate and commercial matters, she has valuable experience and specializes in intellectual property matters, more specifically to patents, copyrights, trademark-related litigations, etc. She undertakes intellectual property prosecution and represents clients before the IP offices all over India. She advises clients in transactions involving IP, particularly those pertaining to film production, content creation for television, broadcasting, streaming, etc. And Sheetal holds an LLM with a specialization in intellectual property law from the University of Toronto. And she has authored a thesis as well on copyright designs and on the copyright design conundrum. So over to you, Sheetal.
Thank you. Okay, so since many of you already practice in this area, is anybody able to readily tell me what the difference is between an assignment and a license of intellectual property? Depending on an answer.
Assignment is like a sale, you get it transferred to the other party. He becomes the owner, and license is just to use it on license basis. You pay a license fee for that.
Right. That's right. Okay. So
but in license, ma'am, key ownership is not transferred to the license. So see.
Right. Absolutely. Yeah. Then what is transfer?
Transfer is to give your ownership, like in assignment, where we transfer the ownership rights to the assignees.
Yeah. In license, what is getting transferred then?
The rights to use.
Perfect. Yeah. So that is, in short, the difference between assignment and license. So this becomes important in intellectual property for various reasons. But can anybody tell me why intellectual property contracting is crucial? Why does it matter?
To protect the process of the business, or to protect the secret of how the business is proceeded. And to gain the complete rights over the work you are providing.
Yeah. So you have contours within. You set contours within which you allow the person to operate. Right. You have certain things you want to allow and certain things you want to disallow, and this emerges very directly from the fact that intellectual property is always a bundle of rights. It's not like a piece of, anything is a bundle of rights. Even if you think about real property in respect of land, the rights that you get along with it are a bundle of rights. The right to use it, the right to transfer it, the right to lease it, the right to convey it, the right to license it. License is there even in respect of real property, right? And you have other neighboring rights associated with it, the right of way, easements, and other things like that and other appurtenances that get associated with your land. Similarly, in intellectual property as well, it's of course the rights pertain to one piece of work, whether it is a copyrightable work or a trademark or a invention that is patentable. But essentially what you're getting along with it is a bundle of rights. So if we go back to when we discussed copyright, can somebody tell me what the bundle of rights are that you get along with a copyright? What are all the rights that come along with a copyright?
Right to reproduce the work.
Very good. Anything else you can add on?
To perform the work in front of other people for monetary purposes, To
Yeah.
reproduce copies of it.
Yes. Reproduce done.
Uh,
Perform the work done. What else?
To protect the exclusivity of the work.
Sure. Yeah. Okay. So these are all the bundle of rights that come with copyright, right? So the thing about intellectual property is you can always, it's a very malleable sort of protection. You can mold it in whatever in whatever way you want, and retain what you want and give away what you don't want, right? So it is possible for you to take let's say a film, a cinematograph film, and I can give a limited right to. I can always part with it in pieces, essentially, and and all of them can coexist. So I'll explain to you how that happens, right? So in a film, the producer, according to the Copyright Act, the producer owns the film. So the film uh, is distributed in theaters. So these distribution rights only are specifically given to theater distributors. Further, the distribution rights are sort of split into territories. So they give South India film distribution to one distributor. They give North India film distribution to another distributor. You can authorize someone to distribute the film only in Dubai. So you can also territorially split it, and that is only with respect to distribution, right? You have another right of streaming, which you can only give to platforms like Netflix, Amazon Prime, or whatever other streaming services are available. And you can also give them either on an exclusive or non-exclusive basis. So if you notice, a lot of older Hindi films that came in the early millennium are available on multiple streaming platforms. That is because the person who owns the film has chosen to split the rights in such a way that I'm sorry, each person that he is allowing to stream the film only has the right on a non exclusive basis. And similarly, the same can be done with network broadcast. So, network broadcast is where the film is being distributed on television channels. So, even that can be split between channels. Again, he can retain the right of dubbing the film and give dubbing rights for each language specifically to different people. So the odd thing about all of this is everything pertains to the same piece of work. And there are so many facets to it that the producer can choose to split it, separate it, and give it away in whatever manner he pleases. So the basics of that resides in the difference between the assignment and the license of something. So that is the most basic difference. But beyond that, also, like I just explained, there are many ways to split a work and give it away. So I'll just sum up the differences, although just to bring everyone on the same page. Assignment and license are, of course, different from each other in that assignment results in the transfer of title, and license does not result in the transfer of title. Assignment is always exclusive in nature. So if I assign the rights of something to you, I can only do it on an exclusive basis because I'm giving away title to it to you, right? So I can either give you a part assignment or a full assignment. So I can assign the entire film to you, including all bundles of rights that I have available with me under copyright law. Or I can give you only specific aspects that I want to give away. For instance, I can assign to you specifically only the right to stream it on Netflix, right? And a license, on the other hand, can be exclusive or non-exclusive. An assignment is obviously permanent, except to the exclusion of Section 19(4) under the Copyright Act. I think it's a very technical thing. I don't want to get into it. But basically, assignment normally, in the normal sense, in the regular sense, would be permanent in nature because you're giving something away. So unless you take it back or it comes back to you by operation of law, it remains with the person that you've transferred it to. A license, on the other hand, can be for any period of time. An assignment usually is unconditional. I mean, it largely depends on the type of condition we're really discussing, but on the use of it itself, there cannot be any limitation. But that is not the case with a license. You can make it as narrow or as broad as you please. Okay. Before I go to the next section, Pratima, is there a different lecture that's going to happen on the drafting of contracts? You're on mute, Pratima.
Sorry, no, we don't have a separate session on contract drafting, but in the previous class, we did discuss some of the key elements of contracts and specific to IP contracts.
Okay. So there might be a little bit of overlap, guys, but I'm going to talk about very specialized contracts, so it shouldn't be too much of an overlap.
Sure.
Okay, so now I'll just in briefly just get into how transfer of rights works with each body of intellectual property law. We'll go on this topic for another 15 minutes, and then I'll jump into the drafting of intellectual property contracts itself and what clauses need to be included and what we need to address in different types of specialized intellectual property contracts. Okay, so all of you are familiar with what a copyright is and all of that, right? I don't have to get into that once again. Yeah?
No, ma'am. Can you give a brief introduction about it?
Okay. Sorry, who was that? I can't see you on video, so I don't know who's
This
talking.
is Nagaraju. Nagaraju is a law student.
Oh, he's a law student.
Yeah.
Okay. You've done IP in college? No, not
No,
yet.
ma'am. It's the first time.
Okay. So copyright is basically the right, simply speaking, the right you have when you've created any work that is artistic, musical, dramatic, or literary. So to give you an example, the right of the author in a book, the right of a composer in the music he composes, the right of a person an architect who makes a building, and the right of a sculptor in his sculpture, all of these fall within the realm of copyright law. So essentially, when you assign or license a copyright, it is coming from the author of the copyright if he's also the owner of the copyright, or the owner of the copyright. So can anybody tell me what the difference is between an author and an owner under copyright law, considering some of you do practice in this area?
Ma'am, publisher is the owner, and under which the author is publishing his book becomes the author. I mean, if I write a book, I'm an author and I'm publishing under some publishing house its owner.
Right. In most cases, what you said is true. I mean, I do have to, when I write the book, I am the author and I am the owner. But I have to enter into some form of publishing agreement to transfer the publication right to the publisher. But once that happens, you're right. The publisher is the owner of the book and I continue to remain the author. So essentially, how you can remember this is the author of a work never changes. Obviously, the person who made the work is always going to be the author. Depending on what the author does with the work, it then the status of ownership can shift from person to person, right? And some works from the very beginning, from their very inception, are already in the possession of the owner, like works for hire. So if you are employed by a person specifically to create something that is copyrightable, and from the very inception of your relationship with them, it is already decided that it's already decided that what you're making is a work for hire, then they become the owner of it from the creation of the copyright itself, right? Another thing you have to remember is joint authors. So there can be two authors who have equal rights in a copyrighted work. So unless there is a contract saying otherwise, joint authors as per law, which is defined under section 2Z of the Copyright Act, refers to a work produced by the collaboration of two or more authors in which contribution of one author can't be distinct from another author. In that case, joint authors always own works also jointly, equally. So you can never give the right away unilaterally. It has to be given by all joint authors together, right? Now, Section 18, Section 19, and Section 19A of the Copyright Act deal with assignment. And you always have to keep in mind what these sections say to ensure that your your assignment is foolproof and good in law, right? So the first aspect that these sections address is consideration. So the author of a work, upon assigning a work, may receive either like a lump sum payment for the entire work or for the entire right that is being transferred, or he can receive the money in terms of share in revenue or royalty. Does any, I mean, you all are familiar with what royalty is, right? Can someone tell me what royalty is?
Franchise agreements it is given, or if you
Sorry?
are giving a license in franchise agreements, if someone is using IP,
Yeah.
in that case the franchisee pays the royalty, as well as if you are giving your copyright or any other IP to the as a license
Yeah.
to the licensee, he will be paying royalty charges for that, depending upon the
Exactly.
goodwill and valuation of the
Yeah.
IP.
So how do you think these payments are done? Like how do you come up with what is the royalty? Any idea?
Upon based on the valuation of the IP, the royalty will be decided.
Yeah, yeah. I think valuation is being addressed later today or tomorrow in one of these sessions. Um, there you'll learn more about how this impacts royalty. But essentially, royalty is a percentage of either the valuation or the revenue that is being earned from a particular work. You share that with the author or the person you got the work from as consideration in exchange for the rights you have acquired from them. Okay. Now, a lot of the times when you're dealing with copyright assignment, some works that you specifically end up dealing with are album productions, which is musical works, right? So in respect of musical works, the Copyright Act underwent in 2012 something that is famously dubbed as the Javed Akhtar amendment, which, I mean, he fought for this, that's why it's named after him. You all know who Javed Akhtar is, right? Yeah. So basically, there was this entire movement in India. There's also a book you can write this reference down. I'll also send an email with this as part of my reading list. Prashant Reddy and Sumati Chandrasekhar have written a book called Create, Copy, and Disrupt. Prashant Reddy is a intellectual property lawyer. This Create, Copy, and Disrupt deals with this aspect. So if you're interested in understanding more about this topic, you can definitely go and read that book. It's very well written. It reads like a story also. So it's very interesting for everybody, whether you're a lawyer or not. It's called Create, Copy, Disrupt. So, as the digital movement in music and film started advancing, what happened was we saw a lot of exploitation at the hands of producers, where they would pay literally peanuts to the person composing the music and the lyricist at the time the song is made, and then rake in millions when the song was finally monetized, which is obviously unfair distribution of wealth from the very beginning, because the person who has actually put in the effort, if you go by John Locke's labor theory, the person who has invested effort should get fair return, right, for his investment. So that doesn't happen. So it's essentially exploitation of the means of production by the producer whose money is being used to produce the music. So they decided to come up with an amendment which is called unassignable royalty. So basically, to protect the interests of authors of literary and musical works which are part of a song or a film, um, they have been given 50% royalty rights, which they cannot assign. The law prevents them from waiving that right. So the producer can't get paperwork signed by them when the work is being made saying, uh, that this is unconditionally being assigned. So what used to happen was producers would get composers and others to sign these agreements at the very beginning when the work was being made, saying whatever royalties I'm entitled to, I'm waiving my right to those and assigning them unconditionally to the producer. So you cannot, this amendment basically prevents you from assigning it at all. In law, it is not permissible for you to assign these rights. So they found this as a way to protect the interests of people who are actually making the music. Okay. So, what these sections say about the manner in which copyright works have to be assigned are six things, right? One is, an assignment to be valid and enforceable has to always be in writing. An assignment cannot be oral, according to the Copyright Act. Okay. While, I mean, the previous class, I'm sure Pratima and Ashok referred to this. According to the Contracts Act, a contract can be oral or written. But the Copyright Act specifically prevents an assignment agreement from being oral. It has to be in writing. It can also be made in respect of a future work, something that is not already in existence, which is strange because you can never like sell future land, right? But it is possible, technically, like buying an apartment that is still under construction. um, Third is you can always decide the scope of the assignment, and that also has to be reduced in writing. Otherwise, it's just assumed that the entire thing is uh, assigned for an unlimited duration. Uh, the payment terms have to be fixed, and the assignment has to be for a specific territory. Otherwise, it is assumed that it is worldwide. And these similar things under section 30 and 30A also apply to licenses. They have to be in writing. They can be in respect of a future work. The scope has to be fixed in writing also. It has to be in exchange for consideration or for payment. And the territory of the license has to be fixed. This is with respect to copyright. Now, let's move to trademark. Someone said they're a trademark agent. Who is that?
I'm trademark attorney.
Yeah. Sorry. Can you explain to everybody what a trademark is? Because I've been saying this too many times to them. Maybe this time you can.
The trademark is basically something which is capable of being graphically represented as a device or a logo. It can be an inscription or a drawing or a word, including combination of color.
Right. Which is, you
So
mistake.
practically, there are two kinds of trademarks only when we file it. It's a word mark or it's a device, and device is further like classified into the logo, shape of goods, or the color combination.
What is the legal function of a trademark? What does it do?
So it does recognize the owner of the source of the product
Exactly.
or the
Yeah. So
services,
it's, yes,
and
it
it
is, yeah, it signifies the source of goods and services. Yeah. Anything else?
protects the brand and reputation if you of the that particular owner of the trademark.
Right, right. Okay. So trademarks can be of two kinds, right? Registered and unregistered. What Hasnain just explained is the process of registration. He briefly touched upon it, but a trademark can also be unregistered. What happens with an unregistered trademark, Hasnain? What
So
happens?
unregistered trademarks are they are basically protected under the common law right of passing off.
Very good. Yeah, can you brief
So
passing off is?
passing off is based. So there are two kinds of actions in trademark act that you can take under section 135. One is of infringement and one is of passing off. A
Yes.
mark is infringed when it is registered.
Mm.
If you have got registration of the mark, then it is infringed. But as per the doctrine of prior use, which is envisaged under section 34,
Mm.
even if the mark is unregistered, but you are able to show that you are the prior user and you have your mark has acquired distinctiveness, so you will be getting protection under the common law rights of
Common
which is
law of
of passing
passing
off.
off. Right. Where someone else is trying to pass themselves off as the source of a product which is actually yours, or a corollary of it, which is they are misrepresenting that their goods are
So,
coming from your source.
so there is one section 27 clause 2 of the Trademark Act,
Mm.
which is on passing off. So
Yeah.
which treats the rights of the prior user superior to the rights of registered user also.
Right. Right. Okay. Okay. So, do you have anything else to add on assignment and license of trademark, Hassan?
So assignment basically means the in that case the ownership gets changed.
Yes.
So you literally sell it to some party
Yeah.
They pay consideration for the same, and
Yeah.
then the rights including all everything are assigned related to that trademark to that assignee.
Right.
And
Do you
in
have
license,
any
you just give
about recordal of assignment under Section 45?
section 45 what?
Recordal of assignment.
Yes, I think it is to be recorded in the trademark
Yes.
registry by
So
file. We have to file a
one
form
difference,
TMP.
right? Yeah. So
There is
a
a
person,
compliance also.
yeah. So basically, once because the trademark registry's database will show one person as the owner. So when you're assigning the mark to somebody else, the agreement and everything in relation to the assignment has to be formally recorded with the trademarks registry under Section 45. This is a peculiarity applicable only in trademark law. Otherwise, it's not otherwise required. Okay, so what can you tell us about goodwill? What is goodwill? Can anybody tell me? Every trademark comes with goodwill. What is goodwill? Okay, famously, Lord MacNaughton said that that it's a thing that is very easy to describe, but a difficult thing to define, which is that goodwill is associated with the mark and is some kind of a uh, an indication of reputation that is associated with a brand name, and goodwill is capable of being transferred because it runs with the mark, right? So if it doesn't matter who owns Coca-Cola today, but Coca-Cola has goodwill of its own, so it doesn't matter who the owner of the mark is anymore, but the goodwill continues to run with the uh, mark. So
Ma'am,
another peculiar
sorry
aspect.
to interrupt, but
Yeah.
can we connect goodwill with the popularity of the brand, or how good the brand has done
Yeah,
in
yeah.
terms of reaching out to public?
Yeah, that's precisely what it is, right? The more the number of people who know it and recognize the mark is obviously adding to the goodwill because that is increasing in reputation of the mark. So I'm sure in the valuation class they will address some aspects of how valuation of goodwill actually occurs. But legally speaking, goodwill is also something that can be transferred or not. So the traditionally the value of a trademark lies in its goodwill, but it's subject to certain conditions. And goodwill is an asset by itself, which can be transferred or otherwise retained with yourself. So let me give you an example of a situation where goodwill is not getting transferred. Okay. So Coca-Cola, let's take the same example. Coca-Cola is a famous beverage brand, right? So obviously its reputation lies in that area. Now, what this reputation is not transferable to whatever else Coca-Cola makes. So tomorrow, can't outrageously start a automobile business and expect to sell cars also just as fast, just because it is Coca-Cola. So let's say as Coca-Cola, I acquire registrations for beverages on the one hand and cars on the other hand. And if I transfer to Tejal only the car Coca-Cola brand, am I transferring goodwill or not? I'm not, because the Coca-Cola brand has no goodwill as far as cars are concerned. The brand has goodwill by itself, but you're getting the mark sans all goodwill because nobody's going to buy a car just because of the brand Coca-Cola, right? So there are, I mean, situations where it's possible to transfer a trademark without goodwill. We'll later come to how this impacts contract drafting. Similarly, licensing of trademarks happens in two ways. One is you can be what the Trademarks Act calls a registered user. Means when there is a trademark licensed in your favor, you can also be entered into the rolls of the registry as as a registered user who is the person who is actually using the mark. So I'll tell you why this becomes important. So, as Hasnain can also confirm, a trademark once registered is valid only if it is continuously being used. Right, Hasnain?
Yes, ma'am.
Yeah, so you have to continuously show use of a trademark. And if I mean, I'll ask Hasnain also to join me in explaining this. Basically, when you want to get a mark removed from the register, that process is called rectification. So one of the
Yes.
grounds for rectifying the register and removing a mark from the register is that the mark is not in use, right, Hasnain? So
Yes,
he'll
yes,
also
correct.
be advising his clients on this aspect that once you register a mark, you have to show continuous use. If someone else is able to establish that you're not continuously using the mark, it becomes a ground to remove it from registration. So in a in a situation where I am the owner, but I authorize someone else to use the mark, it would technically mean that the person who registered the mark is not using it. And it shouldn't become a ground for removal of the mark from the register. So, to get over this, what we do is we register the licensed user as a registered user of the mark, meaning that any use by the registered user of the mark will be valid use for the purposes of trademark law. Any doubts on this? Hassan, you can add anything if I've missed out.
No, no, it's correct.
Yeah, yeah. So there are two concepts in relation to this, that there is a permitted user and a registered user. So a permitted user is obviously someone that has been specifically permitted by the owner to use the trademark.
Means
Okay.
permitted and registered user are one and the same thing.
Yeah. Okay. So next, let's briefly just move on to patents. So in patents as well, the assignment has to be in writing and the scope has to be defined and has to be in exchange for consideration. Another peculiar fact with respect to licensing of uh, patents or copyrights for that matter is that we now have the concept of compulsory licensing. Is anyone familiar with this? Can anyone tell me what compulsory licensing is? Okay, so where the statutory authority set up under the act for this purpose feels that the monopoly of pertaining to a particular product is destructive and operating in destructive ways, and believes that for the good of the public they have to have access to it. They can issue what is called a compulsory license, which means at the rate prescribed by that authority after hearing both sides. The owner of the patent or the copyright is compulsorily supposed to license it to whoever the authority directs, right? So a compulsory license usually helps in cases where there is a life-saving drug that is being sold at prohibitive prices. So the authority can then step in and say this monopoly is not good, and for the sake of public good, we need this life-saving drug to be available at lower prices, so we will allow for it to happen. So other than contractual licensing or assignment, which is happening out of free will and in the open marketplace, um, compulsory licensing is happening by way of a order of court. Okay, so this concludes the first part of what I was going to address. Now I'm going to talk about things to remember uh, while drafting different kinds of intellectual property agreements. So all intellectual property agreements cannot be molded the same way. Because like we just discussed, copyright has separate requirements, trademark has separate requirements, and each of it requires specific expertise and things to be kept in mind. So we'll address some of those very quickly.
Sheetal, sorry to interrupt. Are you sharing the PPTs or something?
Yeah, I thought I'll share them later
Okay,
because
okay,
I'm
all
not
right.
able to share it on screen right now. I have
No,
them.
okay.
I sent it to Dr. Anchal as well, but
Okay, okay.
I'm having some technical difficulty sharing it.
No problem. Sure. And just a quick question before we proceed. So this compulsory license can be applied even to copyrights and trademarks? Or is it
Copyright,
specific?
yes. Copyright, yes. There is a specific provision on compulsory licensing in copyright law, which basically is to ensure that um, works don't remain unpublished. Um, and when people want access, they should have access to it, because intellectual goods are at least philosophically common in nature, right? Everyone should get to enjoy it. So there's generally the belief that society benefits from larger dissemination of work. So to prevent the non-dissemination of anything, this provision has been specifically made in copyright and patent. But in patent, as you are aware, the discussion is largely only around drugs, life-saving drugs.
Medicines and drugs. Yeah, right.
Okay, so I'm just going to take another crack at sharing the PPT. If it doesn't work this time also, then I will. Oh, can you see?
Yes, we can.
Okay. So we've actually moved on from here. Okay. So now this is what we're addressing, right? These are the 10 points that I'm using to sort of explain what you need to keep in mind for all intellectual property contracts in general. Okay. One is in an assignment, you have to do two things definitely. Okay. One is earmark the property correctly. So there has to be a very, very specific definition of what the property uh, is that is being transferred. So in respect of a sale deed for land, you must have all seen it'll have a schedule in the end specifically explaining the location of the piece of land, the boundaries, the area, the door number, and the property tax, whatever the municipal corporation door number associated with it. All of it is provided there only as a manner of identifying exactly what is being transferred. Similarly, in intellectual property, you have to earmark and explain the contours of what exactly is being transferred. That is the first thing that you will do, because, like I said, intellectual property is extremely malleable. You can bend it and shape it exactly the way you want. So, agreements should be as specific as they can possibly be, right? The second thing you need to always indicate in an assignment is a list of the rights that are being given. So are you giving the right to distribute the film to public, or communicate the work to the public, or stream it on a platform, or are you giving satellite rights away, and what territories these apply to? So you have to always give an indicative list of what rights are being given, which generally we call the extent of grant. Similarly, in a license, again, you have to identify the property. Second, you have to explain whether the license is going to be exclusive or non-exclusive. Because if you don't mention that, it will always be deemed to be exclusive. So if it's going to be non-exclusive, you have to specifically say that you are giving this only on a non-exclusive basis, and you are entitled to, as the owner of the copyright, to give it to other people as well, right? The third thing a license has to cover is the capability of the licensee to sub-license further. Can anybody explain what a sub-license is?
I mean, can you please explain exclusive and non-exclusive? What does it actually mean?
Okay, so intellectual property can be given, intellectual property rights can be licensed on an exclusive basis or a non-exclusive basis. So I can enter into an agreement saying my film can be distributed in India exclusively only by Hasnain. That is an exclusive license. I can also do it on a non-exclusive basis, where I can allow Harshit and you and Vidya and Tejal at the same time to have the same extent of rights. But in all these agreements, I have to specifically indicate that the right that is being given to you is on a non-exclusive basis. Is that clear?
So, ma'am, the exclusivity puts restriction on the licensor.
Yes, it does.
Okay.
That is your question, right?
Just,
Whether so once
yes.
I've given it away on an exclusive basis, even I can't use it. That's what you're saying.
Okay, the licensor also cannot use it, that
Yes, yes.
if it's
Usually
on the exclusive basis.
licensor. Yeah, yeah. But usually in franchise arrangements, obviously it's non-exclusive, right? In a franchise agreement, I can't give one franchisee the exclusive right. So I retain the right, and on a non-exclusive basis, all of my franchisees have the right to use my mark, McDonald's or KFC or whatever. Right? All of that is use on a non-exclusive basis. Is that clear?
Yes, ma'am.
Yeah. The next thing to remember is you have to explain whether the licensee is allowed to further sublicense the right or not. Can anybody tell me what sublicense means? It's like a sublease. So basically, if I'm the licensor, I can give a license to Hasnain and give him the right to sublicense that right further to anybody he wants. So I license the trademark ABC Limited to Hasnain for his use and give him also the right to further sublicense it. Then Hasnain is at liberty to sublicense the mark to Pratima for her business as well. So this has to be indicated in the agreement whether a sublicense is permissible or not. Okay, so the next thing to cover is the term and termination. So essentially, you have to always limit a license. Even assignments can be limited by term. So you have to limit the assignment or a license by a particular term and say that this license is being given to XYZ for a period of 10 years. Okay. And at the same time, you also have to be able to uh, terminate the agreement for breach of various material obligations that are in the that are specified in the agreement. So I'll give you an example of this. So in a franchise agreement, let's say McDonald's, right? So McDonald's food is, they give SOPs to where all of their restaurants, specifying the manner in which the food has to be prepared. So any drop in the quality of the end product will have adverse effects on the brand, right? The brand won't the brand name and its reputation will suffer if the product quality falls. So if there are any quality concerns with any of my franchisees, I should have the right to terminate the contract and put an end to it, right? So your contract always has to have a specific termination clause detailing the situations under which the license would come to an end for breach. Is that clear? Can anybody say anything?
Yes, ma'am.
Yeah, yeah, okay. Okay, so can you describe some other situations where intellectual property agreements you think can be terminated? Like I gave you the franchise example, can anybody give me a similar example?
Non-payment of royalties.
Sorry?
Non-payment of royalties.
Very good. Not adhering to your payment obligations. So let's say 2% of the revenue is supposed to come to me every month from the sale of certain goods. If I don't get it, then I should be allowed to terminate the agreement. Very, very good. Any other examples? Anything related to use you can think of in copyright? So let's say I'm allowed to display a film only on network television, like on television channels or whatever. Suddenly, if I put it up on YouTube channel, am I in breach of the agreement or not? I am, right? Because I'm communicating the work in a way that the license doesn't permit me to. So that is another ground for termination. So in this sense, the term and termination should always be specified in an agreement, right? And akin to this is also the specification of territory. So intellectual property rights by their very nature are territorial, but you can further, like I said earlier, split it into territories and give it away. So I can assign the use of a trademark, let's say only in Karnataka, to Tejal, and at the same time I can assign the same trademark for use only in New Delhi territory to Harshit, right? So it really depends on how you've given it away, but the territory always has to be specified in the agreement. So I've come in a logical order on this list. So basically, the first two, assignment and license, relate to the extent to which rights are granted. The second is the term for which such rights are granted and the conditions under which I'll be allowed to terminate. The third is the territory. And the fourth is a consideration. As Pratima and would have addressed in the previous lecture, a contract without consideration is not valid. And like I said, consideration can be of several kinds in intellectual property. It can be a lump sum consideration or a royalty based consideration. And the consideration has to be specified. And if an agreement is not in exchange for consideration, it becomes invalid.
Ma'am, one question I have related to territory.
Yes.
Suppose if I have registered mark in India,
Yeah.
so whether my rights are are only applicable in India, or if someone is using a similar trademark, suppose in Sri Lanka or Pakistan, so whether I can prevent him from using that mark.
I understand. So your registration is limited to India. So you need to have a registered trademark in India to be able to defend yourself in India. Similarly, the trademark has to be registered in the reciprocal territory as well. In your example, it is Sri Lanka, right? So I'll give you a very interesting example. This is actually, in fact, one of the cases that I worked on myself. So this relates to the trademark Burger King. You're familiar with Burger King, right?
Yes, Burger King.
So Burger King had sometime in 2014 or 15 first time tried to launch in India. It came in that some mall in Delhi or Gurgaon or somewhere. So when they tried to step into India, they realized that there is a huge vada pav chain in India that calls itself Burger King. So the question that you asked me just now is exactly the question that came up in that case. Because Burger King was not registered in India at the time, can Burger King stop this vada pav chain from using their mark Burger King in India? Right? And Burger King won that case. And they won it on the basis that Burger King is a worldwide known brand and they have what we call cross-border reputation in India. So a brand should, if it is so popular and has acquired, as you would know in trademark language, secondary meaning, and its reputation spills across its own boundaries into other territories as well, then under common law, they have the right to protect their brand anywhere. But in a normal case, that is not true, and the mark is limited to territory. Does that answer your question?
Yes, ma'am. So it's just like passing off. If you ever it's a common law right remedy.
Exactly.
This case was very similar to the
And
Whirlpool Corporation case.
in the Burger King case, if I'm not wrong, I think there were some registrations that they had, except that they had not, I think they had not used the mark since then in India. So it was not possible to rely on usage in India. So they had to rely on waterfall reputation.
There was some case also Dil Afza which was being registered in Pakistan, and I
Yeah.
think Roo Afza it obtained injunction.
Yeah. Right. Yeah.
So in that case, the Roo Afza has had to do business in Pakistan. Then only they can obtain injunction, or from here only they can obtain restrict them. What is the
So they have to have reputation there. For reputation to exist, that they should have had
okay
business there,
some
or they
business?
should have reputation otherwise.
And if they want to register, suppose Burger King, if it want to register in India, they
They
have
can
to have
register.
a subsidiary office here. They have to have
No,
subsidiary
no,
office
no,
or something, or
no, absolutely not. You can always file, a foreign corporation can obtain a trademark in India. You
thank
don't
you.
have to incorporate an Indian entity to get a trademark in India. But that said, when you're advising your client, generally, you do keep in mind that sometimes it has tax implications. For various tax purposes, a lot of foreign corporations incorporate an Indian entity and then register a trademark in the name of the Indian entity. But in trademark law, it is not a compulsion.
Do you have any articles regarding this cross-border reputation from where I can learn more or gather more information about
Yes,
this?
definitely. I'll share with you. There is a person by name Mark McKenna, a professor in I think Boston, I want to say, or maybe he's somewhere else now. Who has written an excellent article on secondary meaning and cross-border reputation. So I'll send that to you.
Thank you.
I'll share it with Dr. Anchal. She'll share it. Okay. And in any case, what I'll do is I've done this in previous sessions also. I will. I'm going to leave my email ID in the chat box. Just take it and message me in case you have any further questions.
Sheetal, regarding this cross-border reputation, right? It's a very interesting aspect, and especially when it comes to trademarks. Many years back, when we did not really have the internet and the online facilities, so most of what we really advertisements or getting to know a product was either through a print media or maybe through television or
Right.
electronic media. It was very limited in terms
Yeah.
of. So if you remember many years back of the Whirlpool case, though they did not have a market presence in India, but there was quite a bit of advertising that happened in India.
Yeah.
And the name of the term Whirlpool, the trade name Whirlpool was sort of familiar in the Indian markets, though we did not have the product market here.
Right. Right.
That was the scenario back then. But today we have, considering this cross-border reputation itself, it's very easy for us to, be able to find out names, find out existing marks elsewhere across the globe.
Yeah.
So here, I think this cross-border reputation becomes quite a pertinent thing, and
Yes.
liabilities can be quite high because there is already a market presence, irrespective of whether you have the product being marketed in India or they are
Yeah.
targeting the Indian market or whatsoever.
Targeting it. Yeah. And if we go by this universality test, which most courts like to apply, it's essentially meaning that the internet touches everything.
Correct.
So it's very superfluous to say cross-border reputation. The borders don't really exist anymore. That's right.
Right. That's
Yeah.
right. Yeah. Yeah.
That's very interesting.
Interesting.
Yeah. So we were at territory, right? Okay. The next is consideration, of course, that all rights have to be in exchange for payment. Here, I actually have another interesting thing to say. So, if a company is acquiring some intellectual property from an individual, they can also do it for consideration other than cash. That's what it's called. And what they can give that person is shares in the company in exchange for the intellectual property that they are getting, or the technology transfer. It's very, very common in Silicon Valley based employments and things like that, where they get equity in the company for their contribution of intellectual property. That equity will either vest in the form of ESOPs, or by way of at least in India, it's only in two ways: ESOPs, or by way of a preferential allotment of shares. Actually, Pratima may be better placed. She teaches corporate law as well, so she can address this.
That's right. That's right. Yes. Yes.
Okay. So, other than this, contracts generally have what we call representations, warranties, and covenants. Did you cover this, Pratima, earlier?
No, Sheetal, we have not covered that. So the primary areas that we covered were the governing law aspect, the jurisdiction, and the commercial objectives. So these were the three primary areas that we
Governing?
covered.
Sorry?
Governing law. Governing law.
Okay.
So that was something that was covered in the previous session. And then we discussed a bit about the jurisdiction, but the components that you're bringing about are slightly different. And the third one is about the commercial objectives. I mean, keeping in mind the commercial objectives while drafting a contract, an IP contract.
Okay. So usually when you see a contract, all these three things, representations, warranties, and covenants, are muddled. Ideally, we should keep them separate, distinct, and clear. Okay. So I'll just give you a brief. I mean, there is some overlap. It's not very definite, the boundaries between these three things, but I'll just tell you what each of them is aiming to do. A representation is something that refers to an aspect that is in time previous to the contract. Okay, so it occurs first and then only the contract comes. So a representation could be the licensor represents that he or she has the authority to enter into this contract and there is no legal impediment in doing so. So in the contract, as the licensor, I am representing to the other party that I have full authority to give away the rights that I'm claiming to give away. That is a representation. A warranty would normally apply to the condition of a particular product. So in respect of, if the contract is for sale of goods, a warranty could address the condition of the goods as on the date of the sale. In intellectual property, a warranty is not very different from the representation itself. So representations and warranties in an intellectual property in an IP contract would generally include a representation that both parties are authorized to enter into the contract, number one. Two, a representation that the licensor or the assigner is the actual owner of the intellectual property. Third, a representation or warranty that the rights in the intellectual property has not been given away to anybody else and is not in conflict with rights that are assigned or licensed to somebody else. And fourth, that the intellectual property itself does not infringe on any other parties, any third parties' intellectual property rights. So these four guarantees essentially on authority to enter into the contract, the ownership, the no conflict principle with any third party's rights, and fourth, non-infringement of another party's intellectual property rights, have to be captured as representations and warranties in any intellectual property contract. Is that clear? Covenants are usually in the form of future promises, meaning that once the right has been transferred under the agreement, once the rights are transferred, certain things are supposed to take place, right? So if it's whether it is quality restrictions on a franchisee, or whether it is territorial restrictions on any licensee or assignee of copyrighted work, these are things that operate as covenants. So covenants can be enforced against a person after the contract has come into place and is effective. So yeah, Pratima?
Sheetal, one thing regarding this representation and warranty, just for the benefit of all of us here, there is always, especially when it comes to a software product and a license of an IP, a software-related product, there's always this as-is clause, right? So can you explain a little bit about what is this as-is clause when it comes to representation and warranties?
Yeah, so when any property is being transferred, at least in real property, we say as is where is basis, which means that the property is being transferred in the exact condition that it is at the time of the transfer, and the transferee agrees that they are accepting it in that condition. So any non-workability in respect of the code or anything else that comes after the date of the contract cannot be attributed to the transferor, or you can't see compensation for things like that from the transferor, because the transferee is wholeheartedly and willingly accepting the product on an as-is basis.
Right. So maybe you say that this software product is not 100% error-free. There may be a bug in the times to come.
There
So
may be a bug in the times to come. Yeah.
So that's a package that we are licensing to you.
Yeah. So it just speaks to the workability of the product. And also we use it in software specifically because software is so ephemeral, right? Software keeps improving. It's not, nobody writes 100 lines of code and leaves it as it is. It's always being subject to improvement. So I have till 12:45 or
no, we can stretch up to 1 o'clock because we started at 11:30, so we can stretch 1. Sorry.
I might still run short despite 1 o'clock, but anyway, it's okay. I'll try to finish it as fast as possible. So coming to the as is clause, software is very ephemeral and it's always subject to improvement. And like Pratima said, bugs can come up, and bugs are also coming up in the future, in the sense they can come up at any time. And software also has other problems like downtime and things like that. So to cover themselves from liability for all of these things, they do insert what we call an as is clause. And usually these are shrink wrap agreements. So we just agree to them the moment we start using the software. We consent to it the moment we start using the software. Okay, so other than this, there are some standard form clauses. Did you address standard form clauses on?
No, we have not.
Okay, there's nothing great in that. I'll just send a sample of standard form clauses so that everybody is able to see what intellectual property contracts have in general. Okay, so now I'm going to talk about film and music album agreements in copyright, because these are what give rise to most number of disputes in intellectual property contracts in India, at least. Okay, so I'll just talk to you a little bit about what you need to remember while doing film related and music album related agreements. So a film producer is always required to have like thousands of agreements in place, because there are just so many moving parts in a film, right? So some of the main agreements are the producer has an agreement with the composer of the music. I'm only talking about Indian films here because that's mainly where my expertise is also. They have agreements with the composer of the music. They have agreements with the lyricist. They have agreements with the script and screenplay writers. They have agreements with talent meaning the actors. And they have agreements with the principal director, the person who is directing the film. And then they have a separate group of agreements with people who are financing the film. Okay, and then there are agreements with in relation to distribution, and these are of three kinds: streaming, theater distribution, and network distribution. So I'll just address each of these just a little bit, because copyright contracting is actually the most interesting one there is out there. The other trademarks and patents will not have this much variety, so I chose to discuss copyright specifically. So it's basically industry practice for a producer of a film to engage a music composer to compose the music and the background score of the film. So the musical work by itself is a separate work. So you have to enter into a specific agreement with the music producer, either assigning or licensing the work, the musical work, to yourself. And usually producers enter into this agreement. And now it's not legally possible for the composer of the musical work to assign away his rights to royalty. So in India, musical works composers always have a perpetual right to royalty as long as it's being used in the film. Similarly, they have another agreement also in place with the lyricist who's writing the lyrics for the song. So some things you have to, if you're ever in a situation where you have to draft such an agreement, some of the things that you have to remember are to if you're drafting it from the side of the producer, the agreement with the composer and the lyricist must contain a clause that clearly states that all the IP in the musical and the literary works will belong to the producer, because that is what gives him the right to continue to use it in the film. You can limit it to use in the film, in the sense you can specifically say that now and forever the the music and the lyrics can always be used as part of the cinematograph film by the producer. Second, you have to include a clause that gives the producer some creative control. This is interesting because you know how Indian films work, right? The song is always situated in a larger context in the film. So every song that the composer makes has to fit into the larger story that the producer is trying to tell in the film, and it has to fit with the script, right? So the scene can't I mean, as per the screenplay, the scene can't be Shah Rukh Khan and Kajal are in the desert and there is some love in the air and all of that, and the song doesn't fit with this, right? And it's too fast paced or something like that. So while the music composer is making the music, the producer retains some creative control of what the song should be like and how it fits with the rest of the uh, work. And the third most important thing is scheduling. So, let me tell you a little bit about how financing works in films. So, what happens is the producer raises a round of funds from whatever sources are available to him or her, and they start utilizing this money to enter into agreements with composers and lyricists and scriptwriters to get the ball rolling. So, the longer the music composer or the lyricist or the screenplay writer takes to deliver the work, the producer is spending more money because he has to pay interest on loans that he has taken, and he otherwise probably owes periodic payments to under loans that he has taken. So financing is it's a rolling concept. So money comes in, you spend it on something else, the film production has moved a step forward, and you have to bring in some more money to finance the rest of the film, and this keeps cyclically going on till the film is completely made. So in every film contract, the most crucial thing becomes the scheduling. So you have always the concept in contract law of this is called time is of essence. So in every contract that is related to film, time is always of the essence, meaning that if you have to stick to a particular schedule, and as the creator of the work, if you haven't delivered the product within a certain period of time, you have to be subject to penalties, including possible termination of the contract. But basically time is money, so the ball has to keep rolling. So you have to come up with specific timelines and scheduling in every contract. Now I'll just address the agreement with the writers. So some of the most recent disputes in films in India has been in respect of what rights the scriptwriter has transferred to the producer. So the script always contains a story, right? And the script is usually the original idea of the writer of the script. And how the industry works is normally a person comes up with the script and he doesn't have the means to make a film out of it in any case. So what the scriptwriter does is he approaches a producer who then finds a way to bring in the money to make the film, right? So everything entirely is centered on this key and principal relationship between the producer of the film and the writer. So, in some situations, the writer retains the rights in the script and gives the producer a very limited right a one-time right of making one Hindi film based on the script, while he retains the right to do whatever else with the script he wants, including making similar films in other languages, right? But sometimes the writer gives away the script to the producer in exchange for whatever money. All this is based on commercial considerations that operate between the writer and the producer. But the point is, you are the person who comes in between to reduce this to writing. So you should be aware of what the structure of the transaction is and how you're going to capture this in the agreement. And recently, including in the case of Tyagarajan and Kumar Raja and other writers, this dispute has always come up with producers, right? So the first thing you need to remember is whether it is the intention of the producer to remake or make sequels of the film. Now, if the producer wants to remake the film or make a sequel, the producer has to own the script. The writer can't, right? Because, like I said, what you're giving is important. So if you've given a one time right to make one film out of it, and there's no specific inclusion of the right to make a remake or a sequel, then the producer doesn't automatically get the right to make a remake or a sequel, because courts have held that remakes or sequels are based on the initial script only. They're not based on the film that is based on the script. So you have to specifically include those rights in favor of the producer if that is the case. Otherwise, the writer gets to retain it. The contract must also specify the degree to which creative control is given to each party. This is another very common fight between a writer and a producer. So what happens is the initial draft of the writer's script is shared with the producer. The producer reads it, but then the producer wants something more or something less or something different from the script. So what generally happens, you will see in a large number of disputes in India, at least, this keeps happening on a very informal basis. Drafts keep going back and forth, and before you know it, the producer has had so much creative input in the script that it's very difficult to now separate the writer's contributions from the producer's contributions, because so many drafts have gone back and forth and nobody knows who came up with the script first in any case. And the producer has also requested so many changes that it's now become impossible to separate one from the other. So, to this extent, there are two things that need to be done. One is they have to explain in writing in the agreement itself who has creative control and who owns the script. And this has to be done prior to there being any discussion. So if ever a writer comes to you for advice, your advice should be first enter into this agreement and reduce these terms into writing, and then figure out the rest. Otherwise, this happens all the time. Drafts go back and forth and nobody knows who's the owner of the script anymore, and the script is just lying there in no man's land. And they'll all reach a point where they can't stand each other, and then they have to go to court. The next other thing that you need to remember is the characters that the writer has come up with. So some characters are so unique, right? Like Salman Khan's character in Dabang, or that was actually an actual dispute that came up before the Bombay High Court. So who retains the right to the character? Is it the writer or the producer? Because if you retain the right to the character, you can make other sequels based on that character if you are the producer of the film. But if you don't retain the rights to the character, then it really depends. You may have to go back to the writer for a license. So again, the intention of parties becomes very important. So I've addressed most things that are specific to film related agreements. We've also run out of time, I think. I still have 3 more sections, but what I'll do is I've written an article on this myself, which is available on Mondac. It's free to access to everybody. I'll just share the links and you can take a look at it whenever you have time. Yeah, I think we can stop here for today.
And Sheetal, if you could also please share the details of the book that you were mentioning during the presentation.
Safe copy disrupt. I'll do that. Yeah.
Yeah, and any other articles of the sort, if you can
I
just
will.
share with us, we will forward it to the participants.
I can do that.
All right. So thank you, Sheetal. And this was, again, a new perspective of how IP transfers happen. In the last session, as the participants experienced, we had been talking quite a bit about what is licensing and assignment. Licensing, assignment were the two words that we continuously used. But during this session, we have actually explained about licensing assignments and the types of licensing that happens, and very specific to certain clauses in the agreement also, like the royalty, the consideration clause, the jurisdiction clause, and the importance of a representation warranty clause, because that's like the heart of this agreement, of what I'm actually going to give you, and the covenants. So these were some of the important key takeaways that we had during this really interesting discussion on IP transfers. Thank you very much. And should the participants have any further questions, please reach out to Sheetal or write to us, write to any of us at EBC. We will forward to Sheetal, or we will have a conversation going further, and let the discussions continue. And please do work on the subject. Yep. Thank you. Thank you all. So with this, we come to the end of this session, and we will come back at 1:30. Is that right? Or is that too short a time? Would you want to take a break till about 1:45 or so? Whatever works with you all. 1:30 is the scheduled time, but since we have slightly overshot on the time in both the sessions, I would leave it to the participants.
Okay, make it 140. It's okay.
1:40?
145, whatever maybe.
1:45? All right. Okay, let's resume at 1:45. And we have a session on technology transfers and know-how.
Yes.
Okay. So look forward to catch you up during the noon session. Thank you all. And thank you, Sheetal. Thanks for the wonderful.
Thank you, ma'am.